Direct Effect by Camilla Chadder. What is direct effect? Direct effect is one of three mechanisms whereby individuals can enforce the EU rights prescribed by EU legislation. So with direct effect, the legislation is directly enforced before a national court. There are two types of direct effect, vertical and horizontal. Vertical direct effect means that the legislation is being enforced before a national court against the state or an emanation of the state. Horizontal direct effect, on the other hand, means that the legislation is being enforced before a national court against private individuals. In order to use direct effect, there are three things we must do. First, we must establish that the law in question is capable of being directly effective, as not all law will be. And remember, there are different types of law, from directives to regulations. The second is we need to show that the law that is capable of being directly effective meets the relevant criteria, otherwise it cannot be used. And for directives, this relevant criteria also requires that the defendant in the case be a state body or an emanation of the state. So the first step is to discern whether the law we're looking at is actually capable of being directly effective. There are three main types of law: treaty article, regulations, and directives. Let's start with treaty articles. These are a type of primary legislation. There's no discretion in implementing this, you're bound by it. And so this type of law, these articles will have both horizontal and vertical direct effect. For example, the Van Gent case concerned Article 30 of the TFEU, and this prohibits customs duties, yet the Dutch government had charged for German imports, and so they were able to bring charges on the basis that it's directly effective, Article 30 of the TFEU. And similarly, in Defram, a lady brought action against the Belgium airline, which is a private individual, so it's a horizontal direct effect, using Article 157 of the TFEU, which concerns equal pay. Even though regulations are secondary legislation, they are quite similar to treaty articles, in that they take effect immediately without further implementation, thus making them both capable of being horizontally and vertically directly effective. So the cases that show this are L'Inizio, an Italian minister, where the government refused to pay cash for EU regulations which were trying to reduce milk production, and the claimant here slaughtered 5 of his dairy cows, and so he needed to be paid compensation, which the government refused to do, and he was able to directly rely on these regulations. And similarly, horizontal direct effect is shown in the case of Antonio Munizio. Directives, on the other hand, are quite different, as they are binding as to the result they produce or the outcome they want to get out. So what they do is they offer member states wide discretion in how they're implemented, and usually 3 years is given for the implementation of directives. As a result, they are only directly effective vertically, i.e. can only be used against a state body or an emanation of the state. The case of Van Dunn said that if you didn't do this, then this would make directives useless and it would reduce their effectiveness. And Marshall's judgment, which we'll see later, clearly sets out that directives can only be used vertically and not horizontally. If the regulation or treaty article in question is capable of being directly effective, we must see that it meets a certain criteria in order to be utilised. This criteria is the Van Gent criteria. The criteria states that the regulation or treaty article must be clear, precise, and unconditional. So what do we mean? Clear as to what is the point of the law, what is it trying to get across. Precise is talking about the language, so if it's prohibiting certain hours of something, it gives the exact number of hours, doesn't just say excessive hours or an average amount of hours. And unconditional refers to the fact that it must not be the law must not be conditioned upon a certain any kind of criteria or condition that may be present. The reason why the same criteria is used for regulations and treaty articles is because they offer member states no discretion in implementation, they just straight away apply. Directives, on the other hand, as mentioned before, they do require the exercise of discretion for implementation because they're binding only as to their results, and that's why member states have a bit of freedom in how they wish to implement them, and usually a 3 years time limit also. So therefore, not only does the Van Gen criteria need to be satisfied, we have something called the Ratty criteria, which essentially is just the fact that has the directive passed the deadline for implementation. If it has, then fine, it can be directly effective. If it hasn't, then it cannot. As directives only have vertical direct effect, the defendant must be shown to be a state body or an emanation of the state. So this is what distinguishes the case from Marshall to Duke, because they both have the same facts, except for that in Duke the employer was a private body and in Marshall it was a state body, and that's why in Marshall the directive could be directly effective. So why is this? Well, in Marshall it's pointed out that if this was not the case, there was no vertical direct effect of directives, then member states could take advantage of their own failings in implementing directives. And it's also linked to the idea of not being too onerous on private individuals that have abided as good citizens by the national law as it currently stands, and has no involvement in whether or not the state implements the directive and in what way it's implemented. So how do we prove whether the defendant is a state body or an emanation of the state? Well, the criteria is set out in Foster and British Gas. There are 3 requirements. The first is the defendant must be under a statutory duty to provide a public service. So, for example, in Rolls-Royce, even though there was state control of Rolls-Royce, there was no statutory duty to provide a public service, and so it failed. And the second requirement is that the defendant must be under state regulation. So, for example, it would suffice if the industry is under state control. So, for example, in Griffin and Southwest Water Services Limited, the water services industry had a lot of state control. And finally, the defendant must have special powers. So in Griffin, the power to install a temporary hosepipe ban was sufficient to prove this. But do note, not all 3 criteria need to be met. 2 is sufficient, as seen in NUT and St Mary's. In conclusion, once direct effect can be established, then the claimant can use the particular EU law in a national court to enforce their EU rights. The defendant will usually be an employer in the case, or the party that has done wrong by them, as opposed to the state itself, which is usually in the case of state liability. If direct effect cannot be established, then the claimant may possibly have a claim by indirect effect or by making the state liable. Thank you for watching.